Good afternoon, all, and welcome to the Society of Rule for the Rule of Law's webinar on the pardon power. Excited to have so many people signed up to watch us live. And I will remind you also that we record all our programming, and you could visit this program later on our YouTube channel or see some of our previous content there. If you're not familiar with the Society for the Rule of Law is a membership organization of conservative and libertarian lawyers and friends who are interested in and committed to the defense of the rule of law, the Constitution, and the American experiment. We do this through programming like what we're doing today and some targeted advocacy and membership events. All of our work is made possible by our members. So if you are not a member today, I would really encourage you to think about joining. Membership is at a variety of levels and it is open to lawyers and non-lawyers alike. Quick word before we get into our programming today about some upcoming events. On June 4th, which I think is just in 2 weeks at 6 p.m. in the evening, we're going to be hosting a book talk and reception with Robert Kagan on his new book, Rebellion, about what he calls the anti-liberal tradition in America. Dr. Kagan will be in conversation with former acting Attorney General of the United States, Peter Keisler, who is one of our advisory council members. Tony from the Society, who's in our chat, will drop a link to that event so you could register today. Also coming up in June on the 20th in the evening, we're going to host our first annual Summer Associate Reception. Lots of the leaders of the Society will be there, and for law students in the area in DC, it will be a great opportunity to network and learn about the work of the Society. Now to our main event. Before we open it, I'm going to invite opening comments from each of our esteemed panelists, and we are going to try to leave about 15 minutes at the end of the session for questions from the audience. Questions are best presented by typing them into the chat, and I will kind of scan them as we go and try to consolidate and ask some of the most incisive questions we have. And with that, let me just introduce our three excellent panelists. First, we will be hearing from Gary Schmitt, who is a senior fellow at the American Enterprise Institute and has written a great deal on executive power, the office of the presidency, and specifically on the pardon power. He has a recent piece that he co-authored on the possibilities of self-pardons, and we could link to that as well in the chat. Second up will be Justin Florence, who is the managing director and co-founder of Protect Democracy. He is also the co-author of a recent white paper from Protect Democracy on options to check abuses and misuses of presidential pardons. Justin also is a veteran of the White House Counsel's Office and has some perspectives as a former insider to these kinds of questions. Finally, but not least, we will hear from Shannen Coffin, a friend of mine and a partner at Steptoe and former counsel to the Vice President of the United States, Vice President Cheney. So he also has a terrific inside view on executive power. Really looking forward to this conversation. I know you all are too. So let's get started, and I'll invite Gary to begin our discussion. Thank you, Gary.
Thanks, Gregg. I should begin with a small caveat, which is that I'm a political scientist and only occasionally play a lawyer on TV. So I approach this topic from constitutional history and also concern about constitutional text. I take as guidance, Justice Scalia's famous line, "The text is the law, and it is the text that must be observed." Now, those in favor of, well, let me start off by, I'm going to talk about self-pardon to begin with, and then broaden out the discussion to presidential pardons more broadly. But those who argue in favor of the possibility of a president pardoning himself usually turn to the text and note that there's only two exceptions to the pardon power. The first one being that pardons only are for federal crimes, and secondarily that they, or not secondarily, but the second point being that they cannot be issued in cases of impeachments. I think those textual arguments are, useful to keep in mind, but I also think it's interesting that as a matter of text, they overlook perhaps the core issue of the text, which is the etymology of the word pardon, which is from French and Latin and essentially means to give. Secondarily, there's the word grant. President grants reprieves and pardons. Taken together, what you have is the fact that pardons are about giving something to somebody else. And so you need two people. So it's a little bit incongruous to talk about self-pardons because it would have made no sense to those drafting the Constitution and using the language they did. In fact, if you looked at the dictionaries of the time, it would be impossible to find any notion of a self-pardon making any sense whatsoever. But we also have some, historical evidence that self-pardons were not thought to be something that was possible. When we look at the convention, Constitutional Convention, towards the end of the convention, there was a discussion about the pardon power that the president had been given. And then Governor of Virginia Randolph objected to the power on the grounds that a president who might be involved in a conspiracy, a traitorous conspiracy, would pardon those involved in the conspiracy, thus hiding his own participation in that conspiracy. In response, James Wilson, the delegate from Pennsylvania, argued that pardon power used in such a way would be liable for the president would be liable for impeachment and also criminal prosecution. And so if self-pardons were a real possibility, the exchange would have made no sense. After all, the president could have pardoned himself and therefore undermined the deterrent authority that Wilson was putting forward about impeachments and prosecutions. Secondarily, if self-pardons were actually a possibility or thought about as a possibility, one would have expected the anti-federalists to raise that as an objection. After all, they were always looking for some reason to object, to criticize the draft Constitution. And the very fact that they were so sensitive to the possibility of the presidency becoming some sort of quasi-monarch, the idea that they wouldn't have raised self-pardon as a criticism is evidence that nobody at the time of the drafting of the Constitution thought this was a constitutional possibility. The other point I want to make in this more broadly is Wilson indicates the president can be indicted for the use of a prerogative if pardon power is being used for criminal purposes. In 1790, in his law lectures, Wilson makes a remark that the president is amenable to the law in his private character as a citizen and his public character by impeachment. I take that to mean that Wilson understood that when a president uses what appears to be an authority of his, but if it's used for untoward purposes, the president can be impeached, and if it's used to cover up a crime or in pursuance of a crime, the president can be indicted and charged with a crime. Now, broader still, I think one has to understand that when they thought about such a prerogative as pardon, they would have gone back to John Locke and looked at his example of the pardon power, in which case the example is a house is on fire, a neighbor worried about his own house in the neighborhood goes about destroying that house and is pardoned for doing so. With the point being for Locke and the use of the prerogative of pardon is that it's the use, it's the ends for which the action was taken, so for a public good. Hence, the legitimacy of a pardon rests not only by where it resides in the Constitution, in this case in Article 2 with the president, but also its use. And then finally, I just want to make a remark that we often talk about the pardon power as being plenary, and it is in certain respects. But I also want to point out that this is all within the context of Article 2, which, if you carefully examine Article 2 as a text, what you discover is that there is a very clear delineation between the president's powers and his duties. And indeed, the whole article is is constructed in such a way as to emphasize that. So in Section 1 of Article 2, you have the executive vesting provision, power of the executive residing with the president. But then you also end with the oath of office, those duties, both to faithfully execute the office, but also to preserve and protect the Constitution. The second section is a list of authorities that the president has. But the third section is also just a list of duties put upon the president to keep the constitutional order and fine fiddle. And finally, Section 4 of Article 2 is a discussion or is a list of those things in which the president's use of his powers, in which he violates either bribery or treason and or high crimes and misdemeanors, are intended to be the crimes by which a president can be impeached. And specifically, high crimes and misdemeanors, I think, was intended to reach powers that the president legitimately has, but are used for untoward purposes. Not necessarily crimes, but for untoward purposes. So, for example, undermining the rule of law by pardons and the like. So I think if you actually take the text of the Constitution seriously and the text of Article 2 seriously, you can see that self-pardons, in fact, are not understood to be part of the pardon power. And more broadly, that the pardon power itself, even while understood to be sort of plenary and the president and that it resides with the president alone, still is cabined by a list of duties and responsibilities that suggests that the use of the pardon power is not simply an absolute discretion on the part of the president, but it has to be understood for what uses it's being aimed at and used for to be able to justify its legitimacy. So with that, Gregg, over back to you.
Thank you. That was a great way to start us off. And now if Justin can build on that with his view of the situation.
Absolutely. Thank you for hosting this event, for inviting me, and that's a great place to pick up on. I want to cover three things here. The first is to say a bit about the purpose of the pardon power, in many ways building on Gary's remarks. Second is to note ways in which, although the text of that clause is quite broad, the power is not limitless, notwithstanding claims that my own boss in the White House and many other presidents of both parties have made over a long time. And then the third is to say a bit about four categories of pardons that our paper lays out would violate some of those constitutional principles, one of which is the category that we just spoke about, but three others beyond that. So let me start a bit on the purpose of the power, which is to enable acts of grace that serve the public interest. Lots of folks have looked back at some of the founding commentary on this, and like Alexander Hamilton in Federalist Papers talks about the humanity and good policy that arises from this benign prerogative. Chief Justice Marshall uses that phrase, an act of grace. And that is an important piece of this, but it's not the full extent of it. The Supreme Court back in 1927 noted that it is not a private act of grace from an individual who just happens to possess power, but it's rather a constitutional empowerment that the public welfare will be better served. A DC federal court reframed that in a case in the 1970s. The president who exercises that power as the elected representative of all the people must always exercise it in the public interest. And that commandment that pardons are not just a private individual doing private things, but a public demonstration of an official government act for a public purpose really flows from some of the remarks that Gary made about the overall structure and context of Article 2. And in our history, presidents of both parties have really used the pardon power in this way for different reasons in different cases. I know when I was in the White House, I had a chance to look at what exercise of the power some of the prior occupants of the office had used it for and ways in which it brought forward the public grace in their view. President Obama, of course, used the power quite expansively to provide grace to hundreds who had been sentenced under an older outdated and unfair sentencing regime, really building on the work of President Bush, President Reagan, and others before him. So that's the first point. Second point is there is this conventional wisdom, again, President Obama said it at times, that the power is effectively limitless other than those 2 points in the text that Gary alluded to, federal offenses, not in cases of impeachment. And that's not really true. If you look at the course of US history, both recently and back over a couple hundred years, all 3 branches have exercised checks to enforce constraints on the power that go beyond what's in that pardon clause itself. That, of course, makes sense. Our Constitution is no single clause read in isolation. It's several articles, each with several clauses, and they all need to be read and applied together. I think we all could come up with lots of examples of how you could take one constitutional clause, rip it out, apply it in isolation, and it would allow for some pretty problematic things. Commerce Clause gives Congress plenary power to regulate interstate commerce. But Congress, of course, can't use that to prohibit mailing newspapers it doesn't like, because that would violate the First Amendment. Justice Stevens had a line on this in a case about pardons. This was a state case, but the point still holds. He wrote, "No one would contend that a governor could ignore the commands of the Equal Protection Clause and use race, religion, or political affiliation as a standard for granting or denying clemency." A Supreme Court case in the federal context, Schick v. Reed, points out that like any other power that's assigned to any branch of government, the pardon power can't be used in ways that offend the Constitution. So with that kind of overall framework that it is one clause, but a clause among a broader document, let me just kind of rattle off a few ways in which the courts, Congress, the executive branch have applied limits. Looking at judicial cases, federal courts have held a pardon is only valid if it's physically delivered, only valid if the recipient accepts it. Presidents can't pardon civil contempt of court. They can't pardon a crime before it's actually been committed. Pardons can't expunge a conviction. They can't interfere with vested rights of a third party. They can't require that prisoners forfeit constitutional rights. They can't compel the Treasury to dispense funds in violation of the Appropriations Clause. Again, none of those cases is rooted in the Pardon Clause text itself. They're about the interplay between the Pardon Clause and some other part of the Constitution. That's the courts. Congress also has viewed itself as checking pardons that exceed constitutional limits. In the Nixon impeachment articles, the leading article focused on Nixon's dangling of pardons as a form of obstruction. So that's one place where Congress has done that. Congress has regularly used its oversight authority to investigate wrongdoing in the pardon context. And the executive branch itself has also policed constitutional limits on the pardon power. At the end of and in the aftermath of the Clinton administration, the executive branch impaneled a grand jury to investigate the rich pardon as a potential bribe. The Mueller report focuses considerable attention on investigating dangled pardons and whether the dangling of pardons are part of an act of obstruction. And in the Trump administration and before, White House and Justice Department lawyers regularly advise presidents against improper uses of the pardon power, including, for example, some of President Trump's advisors offering pretty stern advice, according to reporting, against a self-pardon. Let me close by kind of taking that foundation that the purpose of the pardon power is to enable acts of mercy in the public interest, that it is bounded by the broader constitutional text and structure, and say just a little bit about 4 categories of pardons that, as our white paper lays out, would exceed those constitutional limits. So the first is really where Gary took us, self-pardons that would operate to place the president outside the law. I want to strongly agree with everything Gary shared about the textual cues you can take from the word pardon, the word grant, some of the constitutional history. Beyond that, the point I raised about the pardon serving a public interest, and in particular, the constitutional elements in Article 2 of the Faithful Execution or Take Care Clause, the oath of office, requiring that the president exercise power in good faith and for the public interest. It's hard to square that public interest commandment with the private benefit that accrues from a self-pardon. Another reason why the self-pardon is problematic in light of broader constitutional texts and principles is the notion that comes up repeatedly that in our system, nobody can be a judge in his own case because of the personal interest that would bias his judgment. We see that going back to early days in Madison, recently in the Caperton case that comes up. So that kind of no judging in your own case. And then also the fundamental notion of our entire constitutional structure that we are a government of laws, and our rulers and those holding power must exercise those laws, not a government of men acting on the whim of any one man, that kind of above the law principle that stands above all. Sensitive of time, so I won't go deep on the other categories, but I'll just kind of allude to them and we can come back to them. So first limitation, no self-pardons. Second category is pardons that would undermine other portions of the Constitution or powers dedicated to other branches of the government. And in particular, for example, a pardon that would impede on the ability of the judiciary to do its job of enforcing its orders and upholding constitutional rights of others. A third category is pardons that would violate criminal laws that Congress has passed validly within the scope of its own constitutional authority to do so. For example, that either through the issuance or dangling or offering of pardons would violate laws on bribery or obstruction of justice. And then a fourth category is pardons that would license and invite future lawbreaking or acts of insurrection on the president's behalf. In particular, a pardon or a dangled pardon that would sanction rebellion, insurrection, intended to keep the president in office or to prevent a peaceful transfer of power. My point in alluding to those, and we lay them out more in the paper and we can dig in more on them, is not necessarily to make predictions about what the Supreme Court that we have now would rule in a particular case, or whether these issues would necessarily be justiciable in a case before the court, but it is to make a broader point that if one takes seriously the constitutional structure, principles, and history, that each of the coordinate branches of government have their own duty to uphold that ultimate values and text and principles of the Constitution, not look at the pardon power in a vacuum, and each can do that. I'll just close with the following, which is that that conventional wisdom I alluded to, that presidents of both power, White House, both parties, White House lawyers historically have made arguments about very broad or nearly limitless pardon power. And I think that is fine enough in a world where the occupants of the Oval Office are generally exercising their powers in the public interest and in accordance with their oath and the faithful execution command of the Take Care Clause. There might be some edge cases, some political blowback. It's all well and good. But used that way, I think the pardon power is unlikely to generally endanger the overall constitutional structure. But when you are not in the Oval exercising the powers of the office in fundamentally good faith, fundamentally in the public interest, but instead for quite narrow self-interest preservation points, these substantive limitations on the power that derive from the Constitution as a whole and the role of the other branches really come into play and take on a serious role in upholding our total constitutional system and ensuring that abuses of power by one person or one branch don't undermine our constitutional republic as a whole. So I will close there and look forward to talking more with everybody. Thanks.
Thank you, Justin. Shannen.
Well, I thought this was about the turkeys, and the abuse of the pardon power that every president has indulged, without regard to any concerns for remorse or the seriousness of the offense. But having wasted 30 seconds on that, let me move on. Look, Gary and Justin have studied this issue much more than I have. I've been involved on both sides of the issue in the White House. My favorite pardon story in the White House that was not successful was, a letter that made the rounds among the lawyers in the White House from golfer John Daly, who was asking President Bush to pardon his fifth ex-wife because she was, she was deserving. It didn't work out for him, but look, I don't have a vested interest in this self-pardon issue. I think it's a bad idea. So let's just start with that. I think it's entirely constitutional. And I think Gary and Justin, you gave a lot of the sort of fundamental principles as to why. First, it is an exercise of the official power of the president granting something to himself in a personal capacity. So the grant doesn't answer the question. And the word pardon doesn't answer the question, because you have a president who has two separate capacities, the private character versus the public character. And it's the United States granting a pardon through the president to the person of the president. So I don't think the text answers the question. And Gary, I'm curious, when you get back on, I've always read the history exactly the opposite as you have, which is to say, there was a debate about a treason exception in the convention, and there may have been language. I think Hamilton may have had language to that effect. I could be wrong on that, but it was rejected. And but the reason they wanted it in there is with enormous foresight from our founding fathers, and you can criticize them all you want, but they were concerned about the president who was involved in the treasonous behavior. They hadn't had one yet, and they were worried about, well, Aaron Burr was around, so there was a good reason to be worried. But it was rejected, and it was rejected in favor of the current clause that says except in cases of impeachment. Now, what that seems to me is a compromise that said, well, we're really worried about the president abusing this power for his own benefit. But we have a political check on it through impeachment. So we're not going to say the president can't do this, but we are saying that Congress can impeach the president if it's abusive. Now, I think it's fair to say that a president who pardons himself for nothing other than personal benefit is abusing his office. And is a fair subject of debate in Congress as to whether he has to go. But I think the very history and text that we pointed out supports rather than undermines the power of the president, not the wisdom, but the power of the president to act, and the power of Congress to say, hell no, not in this case. It's a political issue. At the end of the day, impeachment is a political issue, and impeachment is extraordinarily broad. Do we want presidents to be able to pardon treason? Of course. I mean, not that you wanted to give that power to Andrew Johnson, who wasn't the font of wisdom as president, but there are reasons that the country has to move on, even in cases of treason. We had discussed this prior, and I'm curious to hear your reaction to this as well, gentlemen. The OLC during the Nixon administration actually came down against the Office of Legal Counsel, at the Justice Department, came down against self-pardons. But they offered sort of a very strange workaround, which is that the vice president could pardon the president if he was acting as president when the president had taken, say, a medical leave, as every president has done recently to get a colonoscopy, and that just seems silly that there's such an easy workaround. Of course, there's political accountability for another actor there, the vice president, who might lose his job as well, and might have independent judgment as to why not to do it. But when the text is so broad, there are, Justin's right, there are external limitations, but a lot of the things that Justin talked about were internal limitations. You know, the Jack Bauer pardon. You couldn't watch an episode of 24 a couple decades ago without the president pre-pardoning Jack Bauer for going off and killing people in the future. Of course, that's unlawful, but it's not yet an offense against the United States when nothing has you could say a conspiracy between the president and Jack Bauer, perhaps, but the text actually has an answer there. And, you know, Congress has the power to control certain aspects of the pardon. That is, if there is a bribe or, you know, some conspiracy to commit bribery or and abuse of office. You know, Congress can limit the bribe for sure. The president may be criminally liable for the bribe, but that doesn't affect the authenticity and power of the pardon. That is, the jackass who is doing the bribing may have a perfectly valid pardon, even though he's committed a different crime in the bribery, and the president can go down with him. So anyway, I find the issue fascinating. It's one of those things I can't believe we have to debate. And you know, the current president faces problems in state law, which are beyond his pardon power. And I don't think the governor of New York is going to be helping him out on anything, although a jury might, because that's a fairly specious prosecution going on right now. I'm no fan of Donald Trump, but that prosecution has gotten off the rails in a lot of different ways. But that said, if he is convicted there, self-pardon isn't going to help him at all, because it's not a federal offense that is at issue. You know, Greg, we can move on to questions. There's a lot outside of Donald Trump that's interesting. One more observation, and I think it's current on the left, and I discovered this. So the Department of Justice has a role as an advisory role in the pardon process. And, you know, good practice is to get DOJ's okay before you pardon someone. But, you know, what happens, practically speaking, is that the last 2 months of the presidency is the president, the White House counsel, and DOJ is just flooded with pardon applications. And DOJ has an incredibly slow process that takes sometimes years to deal with. So, you know, what Donald Trump did was take that process and move it to the White House. You can criticize him for doing so in the sense that maybe mistakes get made. And to take an example, there was a mistake made in the Bush administration, and President Bush relied on the Jackson era principle that, you know, you have to have delivery and acceptance of a pardon to actually withdraw a pardon that he had granted but not yet delivered to someone who he didn't realize had given money to his campaign, and the process had gone around DOJ and straight to the White House. So there are real risks, political risks of going that route. But at the end of the day, the power is the president's, and it is entirely his discretion. And so it's his discretion whether to listen to DOJ or whether to listen to White House counsel on these issues. I discovered in representing someone in that very time frame at the end of the Trump administration that DOJ actually puts some artificial limits on even accepting pardon applications. They will not accept pardon applications from foreign persons abroad. That is, if you are convicted of a felony and live in Canada, DOJ will not even consider your request for a pardon. And I had a client that was in exactly that situation. And we had no choice but to go directly to the president, because the president's office that's responsible for helping the president exercise his constitutional authority is putting limitations on how they will advise the president. Now, that sounds like a pretty bad idea. And actually, a lot of friends of this administration are asking the White House and DOJ to reconsider that policy because it hurts immigration policy, because it hurts the ability to forgive someone who wants to come into this country. And so, I mean, it's not just a left-right issue. It's an issue that, while not the most important issue you'll see in the pardon context, is really an interesting thing where DOJ is trying to tell the president, we won't even help you process this particular class, which I thought they worked for him. So at any rate, that's my little add-on, and Greg, we can move to questions.
Yeah, thanks, Shannon. That was great. I think just before I give you any questions or audience questions, maybe Gary and Justin can have the opportunity to react to Shannon's points. You want to start with Gary? Sorry, you're muted, Gary. Gary,
There we go. All right. I do think it's a little bit odd to think of the president self-pardoning himself, you know, in his presidential capacity, or constitutional capacity, then turning his head sideways and saying, "I pardon you, private citizen." I think that's a convoluted formulation that the founders wouldn't even have possibly thought about. No, look, I mean, I think, you know, none of these historical examples are, you know, 100% black and white. But I do think when you're talking about, for example, Wilson's response to Randolph and the Constitutional Convention, he is defending the pardon power. He's defending it precisely for the reasons you've given and Justin's laid out, which is, you know, you didn't want to take away from the president the capacity in times of crisis to be able to issue a pardon, even in cases of treason, if it was in the public good to do so. But secondarily, Wilson then remarks that, you know, not only would the president, if the president was involved in that conspiracy, not only would he be liable for impeachment, of course, but he'd also be liable for indictment and criminal prosecution. It's just hard to square how, you know, giving the president self-pardon and get an out of jail card and preventing him from being actually prosecuted after an indictment. So I just think the logic of Wilson's comments points to the fact that not only is the president politically liable through impeachment, but he's also liable to the normal course of justice. So anyway, so that's my quick and dirty response to your remark.
Justin?
Yeah, thanks. So agree with those points and found myself nodding along a lot to things Shannon was saying. So maybe less divergence than there could have been on some of these topics. And that is to say that, you know, yes, this is a power granted by the Constitution to the president. And also he has to exercise that within certain textual constraints. And also there are other actors in our constitutional system who have to do their jobs here. And, you know, no one of these operates in isolation. And that includes people who do work for the president, but some of whom are confirmed by Congress, like the Attorney General, all of whom take their own oath to uphold the Constitution. And they have to provide sound advice and counsel and consider if that advice is not being heard and or they see the president acting in ways contrary to what they understand his obligations are, to raise the alarm on that, to consider resignations and the like. So that's people within the executive branch. Congress has its own prerogatives here, both to ensure that its laws are enforced and upheld, to conduct oversight, to aid its legislative initiatives, to exercise the impeachment power. The judicial system, including both the kind of investigation and prosecution side of it within DOJ, and the duty of judges in cases and controversies before them, is to kind of weigh all of these principles and all of the different commands within the Constitution and adjudicate those cases. And so when you view the pardon power within the context of that broader set of constitutional actors and constitutional constraints, sure, you can say, yes, this is a power given to the president, and the president can, in isolation, use it fairly broadly, but it is still constrained by all of these other elements. And I'll just, note on one sort of more place of alignment, agree that the processes that both the Justice Department and the White House counsel's office use to process pardons, to review applications, to tee them up for consideration, to make recommendations are things that are not constitutionally commanded. They are tools to aid the president in furtherance of his duty and to help the president exercise this power in the public interest. I know in the Obama administration, there was a lot of consideration given to how to approach clemency for past drug sentences, which the president viewed as unjust because they flowed from a racially discriminatory sentencing scheme. And a whole system was set up to consider applications, to review those individually, to make individual recommendations. But all of that was flowing from the president's views on what was in the public interest and was an effort to guide him in exercising the power that way.
Thank you, Justin. Shannen, curious just about the limits of presidential authority here. Were you advising a president? Would you tell the president that he or she was obliged to cooperate with congressional oversight into how they're exercising their pardon power, or is it a prerogative that is beyond congressional investigation?
I think it's only where Congress has the power to investigate, and I'm quite certain the Congress has no power to regulate the president's pardon power, but they can investigate for impeachment purposes. So it depends on the purpose. If Congress is considering, looking at the Mark Rich pardon for purposes of trying to reform.
Justin referred to Mark Rich as well. I'm not sure that normal people remember this case. You want to just quickly say
it was a midnight pardon by the Clinton administration for a political supporter. It was the details are I believe Mark Rich was on the lam at the time, was very connected to the Clintons, and it was a highly controversial last minute pardon. I think the best thing.
Can I just intervene? The point was that it didn't look like it had any ostensible connection to the public good.
So. That's right. No, it was a political giveaway. And President Bush was extremely sensitive to that concern. And, it led to a dispute between president and vice president after my days in office, so I wasn't part of it, about whether to pardon Scooter Libby. The president had been burned in this one pardon that was brought to him by a former associate White House counsel, had been approved by the current White House counsel, and not properly vetted because it was a political supporter and it was mortgage fraud during the 2008 when the mortgage market was falling apart. And the president felt burned by that and was very abstemious with pardons then and certainly thereafter. And Vice President Cheney pushed very hard to go from commutation to pardon for Scooter Libby, saying we don't leave people on the battlefield, and President Bush said no. So there are a lot of very interesting pardon stories in individual cases. That being the most interesting one during around my tenure as counsel to the vice president. So.
Justin, we have some questions about, and you touched on some of it, but some of the specific things you think Congress or the other branches can do that would be constructive in this area. Specifically, someone's asking about the Protecting Our Democracy Act and what you thought of those reforms. And maybe related, I want to ask you if does the category of abuse or misuse of the pardon power dictate kind of what the remedy might be? Are there cases where a court should disregard a pardon, or is it all up to Congress and impeachment, and does maybe just depend on the nature of the deficiency in your mind?
Sure. So starting with Congress, and agreeing with the notion that Congress does not, as a general matter, have authority to substantively limit the types of offenses for which pardons can be granted or things like that. That said, there are ample things that I think Congress can do. So one is to just speak clearly on its views of what would and would not constitute abuses of the pardon power just through a resolution or the like. Again, it's not that that would have a legally binding constraining effect, but to the extent that this is subject to political checks would make clear where Congress is. Two is the language in the Protecting Our Democracy Act on this, and it's also been introduced in standalone measures. What it does is facilitate oversight and transparency. So in different versions, it either requires certain reporting on what pardons have been issued, or certain materials when there are self-interested pardons be made available. Again, it's not to limit when the president can or can't exercise the power, but to aid Congress in the exercise of its own oversight responsibilities here and prevent abuse. I think another obvious thing that Congress has in its wheelhouse is around constitutional amendment, and obviously a long political road to get there, but there have been members of Congress who have introduced legislation to prevent to amend the Constitution to textually prohibit self-pardons and other forms of abuse.
Lame duck pardons, right? I mean, really, except for the self-pardon, the biggest concern about the pardon power is the lame duck pardon, where the president is no longer truly constitutionally and politically accountable. I guess constitutionally, but not politically accountable.
And if we increasingly seem to be inching towards this view that you can't impeach post presidency, which I disagree with, but that's a widely held view now, and it becomes even more of a
yeah, we have precedent for it now, right?
Yeah.
So you know, putting a temporal limitation on the president's power could have some positive effect, but then again, you're limiting really important presidential authority that could have, say, national security and you know, in terms of foreign offenders who you know, foreign governments are wanting pardons for. So there are circumstances where you really are tying the president's hands to do his job in order to prevent abuse. And that's a trade-off that hasn't led to a constitutional amendment on this. Would a self-pardon lead to a constitutional amendment? Maybe. Yeah. The fact that we're talking about constitutional amendments suggests that it is an open question, at least, as to whether the president can do so.
Yeah, I mean, the lame duck problem is just one of those things that we never cleared up after we decided that presidents could only serve 2 terms. I mean, it's
right.
That's just a constitutional hangnail that we haven't really fixed. I'm curious what you think, whether or not, let's say there was somehow a law or an amendment that would limit these sort of lame duck pardons, but as you say, maybe there's some sort of crisis that requires a pardon. Why wouldn't a president just simply issue a pardon and then say, okay, here's my logic for doing so. It appears to break the law, but I have a higher obligation to preserve and protect and defend the constitutional order.
It's hard to do when you're violating the constitutional text.
Well, can there be constitutional amendments that violate the Constitution?
No.
That's another debate.
I don't think so.
So
you have to find a way to harmonize them, but I mean, constitutional amendments amend the
so
Constitution.
When Lincoln, issues martial law, and it appears to be in violation of the congressional.
great debates of our time.
So, okay, enough of that.
Yeah, no, I mean, I mean, that's, that is one of the great historical questions of the Civil War.
And this does go to something Gregg raised earlier, which are sort of how did the different branches come into play here? And in many situations, the validity of a pardon is never going to make it before a court. But in some situations, it has and it will. And you can come up with any number of ways where that might arise. And one thing that the judiciary can and should do in cases and controversies before it is resolve those legal questions where there are places where one clause of the Constitution is in some conflict with another, or there's some ambiguity. And I think my view, at least, is that courts shouldn't shy away from opining on those matters, again, in cases properly before them. But you can imagine all kinds of scenarios where a pardon like that, a last-minute national security pardon that violates a future hypothetical amendment, does create some sort of controversy that makes its way before a court.
Do any of you have a sort of a view on any specificity requirement in pardons? I mean, I think it's widely agreed that you can't pardon people for future crimes, but presidents have certainly successfully or purportedly pardoned folks such as the former President Nixon for unspecified crimes he may or may not have committed. There are blanket pardons of classifications of people. Do any of these types of things raise concerns in your minds?
Well, I think, I think
that's a political science question, I think.
Yeah. Well, I think the pardon of Nixon for crimes undescribed was not legitimate. And it should have been the case where there were actual indictments and then a pardon. I think that it's a bridge too far. I mean, it's hard to say it's completely unconstitutional because the text doesn't provide enough logic for deciding one way or the other. But it seems to me that's the most problematic of the ones that you mentioned.
Yeah, I don't have a strong take on that, but would just allude to the point I began with around the public interest purpose of the pardon clause. And you might imagine that the more specific the offense or offenses for which are pardoned, the kind of more clear it can be that the president is exercising this in furtherance of his judgment about the public interest. And it's sort of very vague and open-ended, pardons people for all things all the time. I don't know. You might ask some questions about what's really happening there.
Well, there's another starting to go back to the self-pardon question, but Gary made a textualist argument. Justin, your argument was more in the public interest sort of vein. Do you allow the possibility of a publicly interested self-pardon, that a president might have a legitimate public interest and
really good question?
I want to do some thinking. I could imagine you might have one that gets to that public interest prong. I still don't know how it overcomes the textual points around the term grant and the other points that I alluded to around sort of one man who is both judge and jury in his own case, or one man exercising the power to kind of place himself above and beyond the broader legal structure. And so the public interest, in my view, is kind of a general guiding principle here, but doesn't necessarily negate those other factors.
I mean, it goes back to Ford and Nixon, right? I mean, there was enormous consequences to what President Ford did, and huge controversy. I mean, there's still controversy, of course, but I think he had, in history, has the better of the argument that moving past things were the way to go. It's harder to do with a self-pardon, I'll give you that. There's no question it's a much more complicated analysis, but say President Trump gets reelected and we have nothing but national distractions, where people have elected him knowing full well that there are 4 current present prosecutions against him. there's a public interest case to moving on. There's a public interest case to not moving on as well. But it's, I mean, would Donald Trump be making a public interest analysis? It's hard to say. But it is that's a fascinating question.
You sometimes see articles saying, President Biden should pardon President Trump or should have pardoned President Trump. And I think those points are, come in perfectly well to play in that question. You can have whatever views you have on whether that's a good idea or not.
Yeah. No,
I do think it looks,
granted,
very, very different for President Biden to make that determination or, President Nikki Haley to make that determination than for President Trump to make it about himself.
You see some discourse,
but he always has the colonoscopy option.
Don't we all? So if you see some discourse around the idea that pardon should only be wedded to some kind of confession of guilt or something like that on the part of certainly on the part of political actors like a former president, but even more generally, is there any reason to believe that that should matter in this analysis? I mean, is it your experience that the under current practice does the White House and DOJ take into account sort of the disposition of the perspective?
It is a policy preference, to be sure.
Okay.
Is it an immutable policy preference? No, it's not. It doesn't limit the president's discretion. But it's part of the political calculus. I mean, I've seen analysis of history and text that suggests that a pardon requires acceptance of guilt. I'm not the person to make that case. Yeah. But there are scholars that have suggested it is inherent in the text that you can't receive a pardon without remorse. It's just not practice.
Well, can I ask for just, we're almost at the end of the hour, so for any quick final points or thoughts from each of you, and we can go in reverse order before I ask you to start. One thing we didn't talk about, and in case anybody has a thought about it that's helpful here, is how different states approach this, how different governors or foreign countries approach the notion of clemency and pardons. Shannen, just any quick thoughts?
I have no thoughts
on that or anything else. Any other point you want to make?
No, I appreciate the opportunity, the invitation, Gregg, Gary, and Justin. I think your arguments are cogent. I think at the end of the day, however, the issue ends up being political, with a political check on it as well.
Justin?
So we'll echo the thanks and just build on that yes, we're operating in political context, but one in which there are many actors and their ways they exercise their various authorities are shaped by the political environment. And so I think it's vitally important for all of us, for others to be thinking through what these limitations are, what the implications are, and the ways in which it's incumbent on lots of folks to stand up for the Constitution as a whole in where they can, using their tools to prevent abuse and prevent unlawful conduct. Again, thanks.
Thank you, Justin. And Gary?
We're coming up on the 50th anniversary of the House Judiciary Committee, voting to impeach Nixon. And I've been rereading materials on the Nixon, or the Judiciary Committee activities. And I was struck by just how thoughtful, bipartisan that approach to Nixon was. And I worry that when we're talking about pardons and self-pardons, the remedy for curtailing bad actions by the president is impeachment primarily. And I worry about the state of impeachment these days, that we've undermined the very tool that certainly the Constitution anticipated as being a check on the misuse of the pardon power.
You have my very strong agreement on that, Gary. Thank you very much. Thank all three of you for, I thought this was a really engaging and interesting, enlightening conversation. I really am grateful to the three of you for taking your time this afternoon. And just as I wrap up, I want to remind everybody again, we are a membership organization, and if you're interested in programming like this, please consider joining the society. The link is in the chat. Our 2 upcoming events, an in-person event with Bob Kagan on his new book, Rebellion, is on June 4th in the evening here in DC. And on June 20th, also in DC, we're having a summer associate reception. Thank you all for being with us today. And thank you, gentlemen, for this really engaging conversation. This recording will live on our website, on our YouTube page. Follow us there, also on Twitter and LinkedIn. Thank you all very much. Have a wonderful rest of the day.
Thanks, Gregg.
Bye-bye. Thank you.
Thank you.